Hi, my name is Antonio Gastelum and I'm a partner at MEG International Counsel with offices in San Diego and Houston. Today we continue with our series of frequent asked questions that we get. And today's question is, I'm a foreign citizen and I have assets and investments in the US. Do I have to pay estate taxes? The answer when we continue. Join us. The question of I'm a foreigner citizen and I have assets and investments in the US, do I have to pay estate taxes? The answer is it depends. There are certain assets and investments that are excluded from paying estate taxes, but the general rule of thumb is that assets and investments located in the US upon the death of the owner, even if the deceased is a foreign citizen, are subject to tax. Among the assets that are exempt from inheritance tax are the following: life insurance, for instance, bank deposits, portfolio and stock interest, works of art, and shares in equity funds. With regard to bank deposits, it's important to mention that we're truly talking about deposits, not and deposit accounts. We're not talking about investment accounts, which you have a checking account and you can write a check from that account. That is not included. That is not considered a deposit account. So you need to watch that and be careful when you let your attorney know which accounts you have in the U.S. Okay? I would like to dig deeper into this issue on another occasion, but I want to stress the following, because I know that many of you are wondering why U.S. Treasury certificates, U.S. bonds, and U.S. notes, etc., basically government debt, which your investment advisors have assured you that that debt is not subject to estate taxes, and obviously it's not in the list I just gave you. The reason for this is that the law specifically levies estate taxes on the obligations or debts of individuals and legal or private or public U.S. citizens, including the government and the corporation. So the debt includes certificates, treasury certificates, bonds, securities issued by the U.S. government. Now, although this hasn't been discussed yet, this debt is excluded when it is wrapped around portfolio or stock exchange interest. But whenever any of these requirements are not met, the debt ceases to be exempted and therefore subject to U.S. estate taxes. What are the requirements of these wrappers or tax wrappers, as I call them? Well, there are several, but the two most important are that the debt needs to be registered and no more than 10% of the debt can be owned by a single person. And if you meet these two requirements and several others, but these two are the main ones, then that means that the debt can be exempted from estate taxes. So that's what happens with the treasury notes and the bonds, etc. That investment advisors right off the bat tell you, oh no, they're exempt. No, they're not exempt. The reason they're exempt is because they're wrapped around a vehicle of better known as portfolio interest. Okay, and when you meet that requirement, then it's exempt. But you need to be careful with this, because if you unwrap it or if you take the wrapper off and it no longer qualifies as a portfolio interest, then you lose the protection and the exemption, and that debt is subject to U.S. estate taxes. So you really need to be careful when you buy these securities. Now, if any asset or investment that I didn't mention then is subject to estate taxes, even if the owner is a non-resident foreigner, as long as the property is located in the U.S., and in the case of securities, is issued by the U.S. government or a U.S. corporation or person. So you need to keep this in mind, okay? So I hope you enjoyed the answer, enjoyed the video. And if you have any more questions, please schedule an appointment and we can answer those questions for you, okay? See you on the next video. Thank you.